Dear ladies and gentlemen, it is my great pleasure to welcome you on behalf of the Czech Bar Association in our beautiful premises in the heart of Prague. My name is Eva Indruková. I'm the head of the International Department of the Czech Bar Association and also head of the permanent representation of the Czech Bar Association in Brussels. I would also like to introduce my colleague Lenka Volížová because she will be here till Sunday with you. So if there's anything that you need, you can ask her. She's ready to help you. I have to say that I'm really proud that the Czech Bar Association is so active and that it supports us in different international projects, such as this one, the Practical Law Academy. And big thanks goes to both Mr. Ruari O'Neill and Stephen Perret from the Institute of Advanced Legal Skills, our partner in this project, who also secured our wonderful speakers. Thank you all for coming today, sharing our knowledge with us. We appreciate it very much. Finally, it would not have been possible without financial support, thanks to the European funds and thanks to the Visegrad Fund. And we greet our representative of Visegrad Fund here. We were able to reduce the participants' fee to only 100 euros, which was a big success, and we appreciate that very much, so thank you. Finally, I wish you a fruitful discussion, fruitful training. For those of you who came from abroad, I hope you will enjoy your stay in Prague. And now I will give the floor to Stephen, who will be able to introduce our distinguished guests and speakers, and also who will moderate the rest of the afternoon session. Thank you all for attending the Practical Law Academy in Prague, and have fun. Thank you.
Well, first, could I begin just by reciprocating thanks, because we're very grateful that the Czech Bar Association joined us as a partner in this project. And you seemed nice on paper, then you seemed nicer by email, and as we've met each other and spoken to each other more and more often as we got closer to the commencement date of this project, then we've come to learn that international relations at the Czech Bar Association is something absolutely wonderful. So thank you to Eva, to Lenka, and to everyone from the International Relations Department. You've made us feel extremely welcome. Again, I'd reiterate and repeat our thanks for the support from the International Visegrad Fund and from the Justice Programme of the European Union. We're very glad to have Anna Adamczyk with us from the Visegrad Fund today. And quite simply, as Eva said, without their support, then this project wouldn't be happening at all. Now, what we're going to do during this part of the Practical Law Academy is to look at the way in which certain EU instruments affect and impact on the lives of us, we, the peoples of Europe. And those instruments are gathered into three categories. So firstly, there'll be instruments related to criminal law. Secondly, EU instruments related to civil law matters. And then thirdly, on issues of fundamental rights. And in particular, we're going to look at how those instruments have been implemented in the V4 countries. And that's why we're very honoured to have our guests here from all four of those countries as speakers, and indeed in the audience. I will say thanks and introduce the speakers just in a short while. But our aim has been, and is, not just to discuss what the law looks like at the moment, but to forge new relationships and build on existing relationships between academics, practicing lawyers, and institutions within the V4 countries, within the EU as a whole, and to encourage collaborative works, collaborative articles to be written, comparative studies to be made between what life looks like as a lawyer in one country and in another country. So we see this not as the end of something when today finishes and we go for a lovely buffet, again organised by the Czech Bar Association. But we see this as the beginning of something, and we hope that it will lead to many exciting projects and articles in the future. Now, institutional support is necessary to do that. We've already thanked, and I would reiterate our thanks, for the Visegrad Fund and for the EU. Institutional support is a necessary precondition but on its own it's not sufficient. What's necessary is support and engagement of we, the peoples of Europe. Everyone sitting in this room has a role to play in terms of liaising with their colleagues from other member states, engaging in collaborative projects, and telling your clients about how EU law can help them and really make an impact on their life. So we're very pleased that you've been able to join us today. I realise it's the beginning of the World Cup, and some people may have had divided loyalties. I think we will be in the Czech Republic for about the same amount of time as England will be in the World Cup, which is precisely 4 days. But we're very happy that you're all here, and you represent collectively the judiciary, you represent legal advisors, you represent academics, and you represent law students. And again, we want to build bridges and encourage cooperation between all of these various aspects of legal society. So thank you so much for being here. Now, lovely as the buffet will be, we're all here today to listen to our eminent speakers. So that's the final thank you on my list. We're delighted to have with us speakers from all 4 of the V4 countries and beyond, who are experts in a range of legal issues. We're going to begin by looking at criminal law and how 2 EU directives in particular impact on the right to information and the right of access to a lawyer in criminal proceedings. So our first speaker is Mikołaj Pietrzak, who is the Dean of the Warsaw Bar Association, an eminent criminal law lawyer in Poland, and a very committed and passionate human rights lawyer as well. He's also a member of the Social Council of the Office of the Polish Commissioner of Human Rights. So Mikołaj will begin with how these directives have been implemented in Poland. We will then keep with the same 2 directives, and Mirosław Kurtyna, who is, to continue the football analogy, the home team and playing on the home ground, will be telling us what life looks like with those same directives in the Czech Republic. Mirosław Kurtyna is a member of the Czech Bar Association and its criminal law and European law committees, and he's also a board member of the European Criminal Bar Association. We'll then have a short break for coffee, biscuits, brownies, etc., and we'll return wearing civil law hats. Dr. Ferenc Sigali from Péter Pázmány Catholic University in Hungary will be discussing the EU succession regulation and the features and challenges that has presented, particularly from the Hungarian perspective. And then Dr. Miroslav Slashtan from Comenius University in Slovakia will be talking to us about cross-border debt recovery. So we have a wide range of speakers, a wide range of topics, and those are our 4 speakers from the V4 countries. We're also very honoured to have 2 guests with us to provide a non-V4 perspective. And if you're looking for a comparative perspective, then I think it's difficult to find a country that does things any more different to everyone else in the world, certainly within the EU, than the United Kingdom. So we have 2 guests who will be providing us with a perspective about how things look in the United Kingdom, providing comments and maybe questions to our speakers. Both of them are from the Honourable Society of Inner Temple, and the first is John Ryder, QC, who is a senior criminal barrister in England and Wales, formidable advocate, and I hope I won't make him blush if I say also more recently a television star as well, but I'll leave you to ask him questions about his TV career over coffee. Also Dr. Anton van Dellen, an experienced barrister, more from the civil law side of things, commercial and family law in particular. Not to be outdone, I'm not sure whether Anton has a television career, but he certainly has more professions than most of us will ever have in a lifetime, because he was originally trained in neurosurgery before going on to apply that surgical approach to his advocacy. So they'll be with us, and there'll be those of you who are doing the advocacy training as well on Friday, Saturday and Sunday. Both John and Anton will be leading you in that. Okay, so just a final word in terms of procedure to our guests. Everyone will have 30 minutes. I will sit here, and when we're halfway through, I'll give a little knock, and when we have 5 minutes to go, I'll give another little knock. So I'll try to be as inconspicuous as possible, but we do have quite a lot to get through, so I would ask our speakers if they could try and stick to the timings as much as possible. Okay, well, without any further ado, could I please ask our first guest, which is Mikołaj Pietrzak, to come and speak. Thank you.
Please raise the bar. Good afternoon, everyone, and it's a great privilege to be here. Thank you very much for the invitation, Stephen. Perhaps I should start by saying that Stephen omitted one very important fact in his introduction, in that he himself surpasses in television celebrity anyone else in the room. I do apologize, John. You may not know this, but Stephen is very famous in Poland himself for his television appearances, not only for his academic and didactic. So, and he is also a notoriously difficult act to follow. That is not a problem my colleague Mirek Krutina will be facing after my presentation. I am glad that in this respect I can make your work a little harder, a little easier, I'm sorry. Now, could I please ask, just if somebody could tell me how I should be forwarding this? Is it just the arrows? All right. That's it. All right. I'll be speaking today about two very important EU directives which concern principles which are common to all our legal jurisdictions and are basic concepts of procedural fairness within criminal proceedings and, in fact, within civil and constitutional rights of the individual. They're part of the fair trial right and inherently built into the right to defense. That's the right to information and the right to access to a lawyer in criminal proceedings. And these directives, I'm going to be talking about them particularly as they are relevant to the first moments of criminal proceedings, to the beginning of the investigation, or in fact, the moment when people are first detained or first charged. A few words about my experience. I'm a lawyer based in Poland. About 80% of the work I do and my colleagues do in my office is criminal work. We also have, as Stephen mentioned, a bit of a constitutional and human rights background, but we predominantly do criminal defense work. So much of what we're talking about will stem from our practice. I would like to start by giving you a case study which is perhaps shows a great deal about what is happening in Poland right now, but I think which will be relevant to all of your jurisdictions, and you'll find analogical cases throughout Eastern and Central Europe, and also in Western Europe, I'm quite sure. Obywatele RP is the name of an informal group of citizens. It's literally citizens of the Republic. And this is a group of about 200 people throughout Poland who are very vehemently protesting against the current government, which, as you know, is labeled as anti-democratic, illiberal, or populist. And they often protest. That's what they do. And when they protest, they are very often surrounded by groups of police who far outnumber the protesters, which is also very symptomatic of where we are as a democracy in Poland right now. And the case study I'll be telling you about concerns their detention at one of the protests. A group of these people were stopped because of the anti-government protests they were running. And on that backdrop, we're going to speak about the norms, the international standards which apply, in particular the EU directives. How police intervention, how police interaction with these individuals upon their detention should look. And I think it will be no surprise to anyone when I say that there will be a discrepancy between the standards, especially the directive standards, and the case study that you will see. and then perhaps a few words as to explain where this discrepancy comes from. I'm sure you'll identify some phenomena which are typical for your jurisdictions as well. Just in short, the citizens of Poland, Obywatele RP, they're this group of protesters. They were protesting on the 27th of April in 2018 in front of the National Public Prosecutor's Building, where the first meeting of this body called the National Judiciary Council was being held. To make a long story short, this is a constitutional body that's supposed to safeguard the judicial independence, and it was overtaken unconstitutionally by the executive, and they were protesting. A few of them were arrested by the police. The nature of their charges isn't relevant to this story. What is relevant is the moment they were arrested, and when I say arrested, just so we don't get the nomenclature right, because in our different languages, arrest will very often mean what the English will consider pre-trial detention. I'm saying they were physically detained for the short period by the police, which is, of course, legally permitted, and the court within 48 hours must make a decision whether they're going to be detained or not for example, 3 months. The detainees immediately demanded contact with their lawyers upon being taken into custody, and they were detained shortly after 11 a.m., but the first one of them was allowed contact with a lawyer at 12:50, so almost 2 hours later. And this was after repeated requests and refusal to participate in any proceedings with the police until the lawyer got there. In the case of one of the detainees, the police didn't inform her of the reason for her arrest and her rights for about an hour and a half. They also refused to answer her questions during this time. Why am I detained? What am I being charged with? When will my lawyer get here? Has my family been informed? Simply put, for an hour and a half, she had no idea on what grounds she was being detained and what she can do, what her rights are. One of the detainees claimed that they were feeling ill and demanded medical attention. They did not receive that medical attention. One of the policemen told one of the detainees that he would, quote, take him to the basement. The detainee felt, rightly so, felt threatened, understandably. Another one was held against the wall and informed he should now go stand in the corner. Teraz postoisz sobie w kącie. Then he was forcibly dragged physically to the interrogation room as he refused to comply before a lawyer got there. He said he would not go to the interview room until the lawyer was present. Once the lawyer was contacted, however, after multiple requests, the policeman refrained from using physical force and refrained from making threatening comments. After the lawyer arrived, this took place at 1:45 p.m., so the first contact was at 12:50. The lawyer arrived at 1:45 p.m., so almost 3 hours after the first arrest. The police refused to allow a confidential conversation. They said, we don't have a room. I'm sorry, but you can have this conversation here in the corridor. And then the two policemen stood right next to the lawyer and the client and said, we're not listening, but we have to be there in case this man wants to escape. Now, this was behind closed doors inside a police station, just to clarify. Only after that lawyer arrived and after the detainee was allowed to speak with them, the policeman informed the detainees about their rights, both as a person who has just been arrested, so deprived of their liberty, even if only for a few hours, and both in terms of what their rights as a suspect who is being charged are. So one of those rights was the right to contact a lawyer. Now, as you can imagine, that information was a little redundant at that stage because they had already contacted the lawyer because they had demanded it. The police wanted to interrogate the detainees as soon as they arrived at the police station without the presence of a lawyer. The detainees were not interrogated just because they refused to answer any questions. Now, I can tell you from my own practice, very often the detainees are told, it's going to be better for you if you don't contact the lawyer. Or it's a smarter move to talk now. Once the lawyer gets here, things will become more difficult. This is, of course, not recorded in any official record. It's key to understand when the person becomes a suspect. Now, according to domestic statute, the Code of Criminal Proceedings in Poland, they become a suspect formally when the decision is issued to present charges. This isn't an indictment. This is a charge in the preliminary proceedings in the investigation stage. I know that it's a little different in the UK in terms of that status. That's why it's important, because the directive addresses all of our jurisdictions. And very often, when applying the directive, it's important to define what we mean by a suspect or an accused person. Secondly, it's important to understand that formally under Polish law, these people were not yet suspects until they sat down with their lawyer and were presented with charges. They were only detained persons, detainees, if you will. In our case study, the police wanted to question the detainee before they contacted the lawyer. We mentioned that. The usual practice is to interrogate the person before contact with the lawyer takes place. We gathered some statistics in Poland, and they indicate that only about 6% of people who go through the whole investigation stage ever have contact with the lawyer at that stage. So 94% of people will go through an investigation, certainly the first stages of the investigation, without seeing a lawyer. When were they allowed to contact a lawyer? Well, as I've already mentioned, 2 hours is the amount of time it took for them to contact the lawyer just via phone. The police had failed to inform the detainees about the rights to contact that lawyer until the lawyer got there. And this is really critical. The 2 notices they were supposed to receive in writing, in which they were informed of their rights. One, as a person who's just been detained, and the other, as a person who's being charged. They got both of these notices upon the moment when they were going to leave the police station. So after they had been held, interviewed, contacted the lawyer, and then they were asked to sign copies of both of these documents, indicating that they had been informed of their rights. We'll get to that in just a moment. Now, as regards to confidentiality, as I mentioned, the police claimed there was no room available, and the only contact possible was with the presence of the 2 policemen standing next to them in the corridor. The detainees were very particular. They knew their rights because they had been detained several times under anti-government protests. They were prepared. They had consulted their lawyers beforehand, and they knew that they had the right to refuse to make statements. This was something that the police were not very friendly about, because it was not something that they were used to. And so they were very adamant in saying, no, I will not make any statements. But it's important to keep in mind that the police tried to influence them to make statements before the lawyers actually got there, or before they were contacted. So there were failed attempts to interrogate them. It's also important to note, while there is no record to confirm what the detainees say, the detainees say, all of them say the same thing. When I was detained, I knew I was supposed to be informed about my rights at this stage. Nobody told me anything. The first time I was informed about my rights was after the interrogation was over, and I was given this notice of my rights. But I should have been orally informed, at the very least, that I have the right to remain silent, that I have the right to contact the lawyer, and I wasn't informed of anything upon detention. Now, this question will be particularly relevant if their rights have been explained to them at all. They were not explained to them, full stop. Once they were presented with the information in writing, they got a chance to read through that. And I would like you to take a look at what it is they got. It's not very visible, is it? The point is, this is a document which is supposed to be addressed to the typical detainee. Very often a person who's not well educated, certainly not a lawyer, certainly not a person who has been prepared to experience police hospitality. And this is, of course, the Polish version. Now, first of all, it's not in the second person. It doesn't refer to the detainee. The detainee reading it doesn't get the message. You have the right to do the following. You have the right to demand a lawyer. You may refrain from making any statements. It's written in the third person, the arrested person. So that's the term it uses. And it's written practically in quotes from the Code of Criminal Procedure. Now, I'll show you the English language version, because we actually do have an English language version. Take a look at that. That's part of it. That is, ironically enough, the English language version is in much clearer language in English than the Polish language version is in Polish. Now, if you take a look just at the way it's constructed, it refers to paragraphs, it refers to the person detained, criminal procedure, and it's understandable for us. But a typical client of not only mine, I imagine many of the lawyers present in this room, many of the judges who present in this room who deal with criminal cases, will immediately see that this will be completely unintelligible for a typical detainee, a typical suspect. It's very legalese, I think that's the term. The mere fact that it's all cramped together and written in a legal language makes it inaccessible. And very often when this is presented to the detainee, that's the case we had in our case study, it's given to them in 2 copies and sign this, sign right here. There's no time to read it. There's a lot of pressure and just the emotions involved in participating in this event cause even those who do have higher education, who would understand the wording otherwise, to be so stressed out that they don't actually read it and understand it. Now, this was, as I mentioned, they didn't have a chance to sign this because they received these notices upon trying to leave the office. Of course, they were told they couldn't leave until they signed it. By the way, many of them said, all right, lock me up. I'm not going to sign it because I don't want to sign a false statement. I wasn't informed about my rights. But these guys are punk rockers. I mean, they're fighting the system and they're prepared. But a typical detainee will want to get out that door, and they will sign anything because they literally see the door to the police station, and they will sign this. Now, if we go one step back, look at what you see at the bottom: the date and the signature. You won't see the hour. So long as the date is fine, the police will be able to say, well, this was signed and it was given to him. Of course it was given to him immediately upon detention, and of course it was given to him before he was interviewed. There's no hour to indicate when he received the notice. How did the authorities treat the lawyer? In this case, the lawyer was treated respectfully, if not enthusiastically. But the lawyer demanded confidential communication with the client and was quite simply refused. I think it's very important to note once again that as soon as the lawyer got there, or in fact as soon as the contact was made with the lawyer, the client, who had successfully demanded contact with the lawyer was treated differently. Perhaps not courteously, but they were no longer subject to ambiguous remarks or use of physical force to move them from one room to the other. So it made a difference, apparently. Now let's take a look at how it should be. These are the two directives that are very relevant. Miroslav and I have had the pleasure of observing the adoption of these directives and the way that these directives were drafted and negotiated over the past years within what is called the Stockholm Roadmap for procedural rights in criminal proceedings. We'll be making reference to those if you need to write that down in a moment. Now, the principles of these directives are to ensure that there is a common minimal standard of procedural guarantees throughout Europe. The idea being that we need that mutual trust and mutual recognition within Europe because there's the free transfer, the free movement of people and services and goods. And if people are going to be detained in any EU state, they should be able to count on a certain minimal respect for their rights. The concern in adopting these directives was that they would be considered by many states as the maximum that they need to provide, and it would in fact lead to many states lowering the standards of procedural guarantees rather than increasing them. This concept of access to a lawyer and information rights was also based heavily on European Court of Human Rights jurisprudence, especially under Article 6, Section 3 of the European Convention on Human Rights. The court had set very high standards as compared to the standards present, for example, in my jurisdiction, on what guarantees should be afforded to a detainee in the first moments of detention. Yeah, I think that's pretty much what I just went through. I'm sorry I'm not very savvy with the PowerPoint presentations. Now, these directives put forward certain minimal guarantees, as I indicated. There are certain rights that they acquire immediately after becoming a suspect. Now let's put a little thumbtack on that, a pin on that, after becoming a suspect, because that is key to understanding the directives, both of them. They get the right to access to a lawyer. Don't confuse that with the right to legal aid. Much to the regret of of criminal defense lawyers throughout Europe, access to a lawyer and the right to legal aid were divided within the process of creating these minimal European standards. Because legal aid, so the state-appointed lawyers or legal aid lawyers afforded to mainly those who can't afford them because they lack the money to hire their own lawyers, but also to vulnerable suspects. The Commission recognized that would be very difficult to push through the access to a lawyer directive, simply because it would require financial obligations on the part of the state, and many states weren't ready. So the right of access to a lawyer was governed separately on an EU level than the right to legal aid. Free legal advice, if certain conditions, of course, are met. The right to be informed about the charges, a critical right. Why am I being held? What am I being charged with? The right to interpretation and translation, especially relevant in today's Europe with the free movement of people, where so many of our clients come from different jurisdictions. And when I say our clients, I mean the clients not only of lawyers, but of judges and prosecutors as well. The people with whom we deal very often don't speak the language that is the predominant one in the jurisdiction where they are detained. The right to remain silent. We all watch American films. We all learn so much about American culture, but it seems all my clients, I don't know about yours, the one wisdom that they should be getting from these films is that when you are detained, when you are charged, stay quiet until your lawyer comes here. And that seems to be a little pearl of wisdom which just goes right over their heads. Because the most common mistake our clients make is that they start talking, and they talk, and they talk, and they talk. And I think one of the reasons is this scenario you saw in our case study. They're not informed effectively about their rights. They don't read through this very legalese, very technical language in the information notice they get, if they get it before the interview. And most importantly, they have the right to be informed about all of these basic rights in a language that's accessible to them. Now, when does a person become a suspect? If you take a look at the wording of the directive, it goes much further than the scenario I described in the Polish law. You'll remember that Polish law says you become a suspect when you get the decision that you're being charged with a specific crime, a specific offense. So you may be detained, you may be held 48 hours, and at the end of that 48 hours, the police may present you with a written specific decision saying you are being charged with burglary on such and such a date in such and such a place. And that's when you become a suspect. So under domestic law, and I know this is not only in Poland, that's when you become a suspect, and that's when you acquire a suspect's rights. The right to refuse to speak, the right to a lawyer. That's a pivotal moment. But when you take a look at Article 2 of the directive, what it says, the directive applies to suspects or accused persons in criminal proceedings from the time when they are made aware by the competent authorities of a member state, typically the police or prosecutor, by official notification or otherwise, that they are suspected or accused of having committed a criminal offense, and irrespective of whether they are deprived of liberty. That means the first moment the police come into contact with you, searching your premises, by detaining you, or simply by wanting to informally question you in connection with their suspicion that you may be involved in a criminal act, that is the moment you officially become a suspect. No formal decisions are required in that direction. It is the de facto actions of the authorities which make you a suspect. And that moment is pivotal because you acquire certain rights under the directive to access to information about your rights. That is the moment when you should receive information. And secondly, that is the moment when you gain access. You should have access to a lawyer, even if no formal decision was issued. And they should inform you about that, which of course they do not. All right, we seem to have a bit of a mix-up here. Sorry. So, if you take a look at, I'm sorry, we have to see that I've skipped over something significant, but let's move on. This is always a problem with PowerPoint. The absence of a lawyer under the directive should halt the interrogation. As you can see in our case study, that's not what happened. The police made strong efforts to keep things going, both in terms of efficacy. They want to get this done. Their shift is coming to an end. They want it over. They don't really see the need for a lawyer, and it's going to be easier if a lawyer is not there. They're at ease. They can apply pressure, if not physically. They can exert psychological pressure on the detainees. Of course, the detainee has the right to waive the right to a lawyer. But first of all, they have to be instructed that they can waive that right. And more importantly, what are the consequences? What will happen if the lawyer is not present? Similarly, what will happen if I waive the right to remain silent? And that's particularly relevant because the consequences are different in different jurisdictions. So if you get a Pole or a Czech, a Slovak travels to London, and while they're waiting for Mr. Ryder to arrive at the police station, I'm sure he would be a solicitor, wouldn't it? Not a barrister. While they're waiting for a solicitor recommended by Mr. Ryder to arrive at the police station, they may wish to refrain from making a statement. But the consequences of refraining from that, from making a statement, may be different under the law of London and Wales, England and Wales, than they are under Polish law. Polish law, at least formally, states that no negative consequences can be wrought from being silent. It's quite different, if I understand correctly, in England. And similarly, an English gentleman running naked through the streets during a stag party, as is very often the case with our English clients, detained, may feel under pressure to make a statement because he knows full well, being a qualified lawyer in England, a solicitor in fact, that failure to make a statement under English law may be used against him, maybe to his disadvantage, so he makes the statement. That's why this information about the standard is so critical. All right. So, now this is critical. The directive refers to the jurisprudence of the European Court of Human Rights. And I think that statement says it all. The European Court of Human Rights, in several rulings, I'll mention the most significant in a moment, has made it very clear. If the right to access to a lawyer, especially with regard to vulnerable suspects, in the first stages of criminal proceedings, so at the moment you're detained, that very first moment, before charges, before all the formal movements, formal events take place, if you don't have a lawyer there and you make any self-incriminating statements, then that material is irretrievably and unrepairably prejudiced. That will carry forth into the proceedings, into the court proceedings, and will result in there not being a fair trial because the quality of arms will have been violated. You can't fix that. That's why there's such an important role to be played by advocates and judges in working to point out those mistakes made in the first moments of the criminal investigation. We just mentioned that, of course, they should be allowed to contact the lawyer before being questioned. Without undue delay after deprivation of liberty. Now that's a very evaluative statement. You may perhaps some standard of comparison from your own jurisdiction, whether the ability to contact the lawyer by phone just to ask him to come, him or her, after 2 hours is sufficient or insufficient. Another moment where they should be allowed to contact the lawyer upon carrying out by the police any investigative or evidence gathering act. For example, if the person is to be searched, or if they're to be patted down to see if they've got, I don't know, any drugs on their body. When they've been summoned to appear before a court, which has jurisdiction in criminal matters. And of course, that they have to have the possibility of access to a lawyer in a time frame that's sufficient for them to prepare. It's not enough to give them access to a lawyer 1 hour before a court hearing. And of course, Article 4 says that access to a lawyer isn't sufficient on its own. It has to be within circumstances which allow for confidential communication, regardless of whether the contact is by telephone, email, fax, letters, or personally. Now, what can the authorities do before the detainee contacts a lawyer? That's your answer. Not much. There is only one thing they not only can do, but they must do. Inform about rights. They pretty much, under the directive, have no authority to take any other investigating steps unless the right to access to a lawyer has been waived. Now, this all ties into informing about rights. We've already talked about the letter of rights. You saw how the Polish one looked. The information about rights should be oral or in writing, and it should be direct, understandable, and clear. I want to stress this. I have yet to see a policeman or a prosecutor inform a suspect in clear language what their rights are. There's a very easy way of doing it. Listen, you can have a lawyer here. You understand that, right? You can have a lawyer, and maybe you want to call one. Should we call one? That's how you inform somebody that they can have a lawyer. If what you do is you read out the little legalese text, that person is never going to understand what their rights are in that respect. In reality, the language is very official, technical, it's legal language, and to put things bluntly, it's confusing, especially if it's being translated. If you, like we do, have a significant Vietnamese minority, they speak some French and some English, but it's broken French and broken English. So at best, you're getting a translator into English, and they don't understand much. If you're giving them that English language text written in legalese, they're not going to understand anything. Now, this is the draft. This is a good example. This is the example of a letter of rights under the directive. And unfortunately, I see now, please forgive me for not being technically prepared, it's perhaps not very legible, but it's 5 very clear, concise points. Each one of them is written in such a way that it addresses the person reading the text. It says, you have the right to contact a defense lawyer. You have the right to remain silent. It's not written in legal language. It doesn't refer to any paragraphs, sub-paragraphs, or sections, or statute. It just describes the right in a very human language, which is an exceptional event under EU law, by the way. Now, a few reasons. I appreciate I'm running it completely out of time. There are legal and non-legal reasons why this standard is not respected in Poland. I think you'll find them in your jurisdictions as well. The experts' voices, when our law is being reformed to become compliant with, to implement the directives, the Codification Committee, a body of esteemed professors, raised very many reservations. These were completely ignored, and the Codification Committee was subsequently disbanded by this new government, and there is no Codification Committee anymore. So they just got rid of the main opinion-generating body in criminal law. The Ombudsman put forth very many opinions, alarming the civil society that implementation is far from finished, and there are many changes which have to be made in terms of law and practice of law. And the Helsinki Foundation for Human Rights also voiced this very clearly. I'm not going to go into the details, but the problem is the expert voices were completely ignored, as was the voice of the European Criminal Bar Association, by the way. I mentioned this, podejrzany, suspect. There's the problem of terminology. It means one thing in the directive, and it means a completely different thing in our domestic legal systems. The moment you become a suspect is critical for both these directives, and is very different in domestic law, very different under directives. Now, what are the consequences of having no access to a lawyer? I think in the European Criminal Bar Association, we've been talking about the Saldo's Doctrine for 10 years now, since 2008. The Saldo's Doctrine is simply the acquis of the European Court of Human Rights with respect to procedural guarantees for suspects in the first moments of criminal proceedings. There was this very famous ruling in Saldos against Turkey. I think it's one of the better judgments in the criminal sphere of the European Court of Human Rights, that said this: if you have a vulnerable suspect, alcoholic, person with a very low IQ, uneducated, disabilities of any sort, a person who doesn't speak the language, that person is a vulnerable suspect. And that vulnerable suspect must be interviewed with a lawyer present. It's not an option, it's the obligation of the state. And if that lawyer is not present, and that person makes any statements, those statements, if they're used against the suspect in future proceedings, will irrevocably violate the equality of arms principle, and therefore the whole trial will not meet the Article 6, the fair, trial standard, even though the violations took place before the trial itself. It took place in the very first moments of the proceedings. Płonka is our case from the Saldus doctrine, and involved a lady who had allegedly killed her husband and was a complete alcoholic. And she made self-incriminating statements without a lawyer present. Other factors tie into this. People don't know their rights. We have a poorly educated society which doesn't know their rights. Once again, they watch American films but fail to take home the most important elements of those films, as the right to a lawyer, the right to remain silent. Secondly, most citizens, I'm sure it's the same with you, in England as well, most people don't have a lawyer's number in their cell phone. Most people are detained for the first and hopefully the last time in their life, and they're not prepared for that moment. They're not prepared who to call, what's their number. They don't have the solicitor's number in their mobile. So when the police ask, all right, who's your lawyer, who should I call? They have no clue. They don't know the legal market. They don't know the lawyers who do this work. And they certainly don't have their telephone number. The police don't feel obliged to provide a roster of lawyers with their telephone numbers. And most importantly, in many of our jurisdictions, I think England and Wales is a good exception to this. There is a duty scheme. But when you're detained, but you're not yet charged, that critical 48 hours when the police will ask you many informal questions, there is no legal aid scheme. So there's a formal right to access to a lawyer. It's in Article 245 of the Code of Criminal Procedure, and it sounds very important. But there's no legal aid scheme. So if your 17-year-old boy is caught with a joint and was seen taken to the police station on Janowskiego, they say, do you want a lawyer? He says, well, yes, I want one, but I can't afford one. Well, tough. When we charge you, you can ask for a lawyer, but until we charge you, you don't get a lawyer, because there's no legal aid or duty scheme. So it makes the whole right to access to a lawyer for a person who's been detained but not yet charged, that 48 hours makes that right fictional. It exists, but in practice, it's not accessible for detainees. So just so you know, the Helsinki Foundation stated that the Right to Information Directive has been implemented in about 73%, and the right to access to a lawyer only 56%. This leads to many false confessions, people feeling that they'll get out of the police station quicker if they just confess without a lawyer, violations of defense rights, and of course the resulting injustice. And most importantly, it leads to very many European Court of Human Rights cases against Poland under Article 6. I would just like to leave you with one thought. It is the duty of all the lawyers, prosecutors, and judges present in this room and throughout Europe. We are the ones who are responsible for building that standard. If you, as lawyers, and especially as judges, if you get a case where you see that the auto-incriminatory testimony has been made without a lawyer present in the first moments of criminal proceedings, I urge you to consider whether you can apply Article 6 standards to disqualify that testimony. Until we, as jurists, until the courts throughout Europe, especially Eastern and Central Europe, start setting a standard by which even a case which seems obvious for a conviction is sent back with an acquittal because there was no lawyer present at the police station, the police will feel there's no motivation to respect these standards. The police are not disciplined to ensure the participation of a lawyer because they know the cases are going to end up in court, and they know the judges will accept self-incriminating testimony in large part in these cases. Because throughout Eastern Europe and Central Europe, we tend to apply regulations directly without applying standards resulting from Article 6. So it is very rare that a Polish judge will say, well, domestic regulations don't allow me to exclude this testimony, but Article 6 of the European Convention on Human Rights obliges me to exclude this testimony. The directive obliges me to exclude this testimony. I can't convict this person based on this testimony without violating his fair trial and defense rights. So I urge you to help us build that standards in all your jurisdictions. Thank you very much, and I do apologize for far exceeding my time.